Court. So let's begin. Injunction. Injunction is issued to restrain repetition or continuance of breach. Explain. Injunction to restrain repetition or continuance of breach. In any suit, number one, in any suit for restraining the defendant from committing a breach of contract or other injury of any kind, whether compensation is claimed or not, the plaintiff may at any time after commencement of the suit or either before or after judgment apply the court for a temporary injunction to restrain the defendant from committing the breach of contract or injury complained of, or any breach of contract or injury or of a like kind arising out of the same contract or relating to the property or right. That means if any suit is restraining the defendant from committing a breach of contract, any suit is restraining, that means preventing the defendant from committing, that means for breaching the contract. If any case is preventing the defendant from doing breach of contract or other injury of any kind, whether compensation is claimed or not, the plaintiff may at any time after the beginning of the suit or either before or after judgment apply the court for a temporary injunction to prevent the defendant from breach of contract or injury complained of, or any breach of contract or injury of a like kind arising out of the same contract or relating to property or right. That means plaintiff has the right, so has to apply. Plaintiff can have the right to apply to the court for temporary injunction. So what is the prayer for temporary injunction? To prevent the defendant from breach of contract or injury complained of, or any breach of contract or injury of a like kind arising out of the same contract or relating to property or right. Number two, the court may order grant such injunction on such terms of to the duration of injunction, keeping on account, giving security or otherwise as the court thinks fit. That means it will grant the injunction, but it will consider to give security or otherwise as the court thinks fits. Number three, in case of disobedience or breach of any such terms, the court granting an injunction may order the property of the person guilty of such disobedience or breach to be attached, and may also order such person to be detained in the civil prison for a term not exceeding 6 months, unless in the meantime the court directs his release. That means if the order of the court has not been followed, or there is a disobedience or any breach of such terms, court granting an injunction, the court have the power to order the property of the person guilty of such disobedience or breach. That property, his property shall be attached, and order the person to detain in prison, civil prison, up to 6 months, unless in the meantime the court direct his release. Such attachment shall not remain in force for more than 1 year if the disobedience continues. But if the disobedience continues, the attached property may be ordered to be sold by the court. Attachment generally shall not remain more than 1 year. That means attachment shall have the force of up to 1 year. But if there is a persistent disobedience, then the attached property may be sold by the court. Okay. So when an appeal lies against an ex parte order issuing injunction under Order 39, Rule 1 to 4 CPC, explain the consensus of the opinion of the different high court on subject. Appealability of an ex parte order of injunction. That means injunction has been issued without hearing the other party. So can that injunction be appealable? So question of appealability of an ex parte order of injunction was the subject matter of decision of different high courts, and consensus of opinion is in favor of the appealability of such an order. That means the different high court provided judgment which provides for the appealability of the injunction. The case which has such order to be appealable is Amolak Ram versus Saif Singh ILR 750. Okay, so there is a way of appealing the ex parte injunction order. So the contrary view was, however, expressed in the case of Raja Dev Singh versus Kumar Sambhu Krishna Nair, AR 1953, Trav Cochin 240, and Harish Chand versus Durga Devi. In these cases, the above mentioned cases were not brought to the notice of the division bench which decided these cases. In these cases, the relevant provisions bearing on the subject were also noticed or discussed. Therefore, on a review of the authorities mentioned above on the relevant provision of Order 39, Rule 1 and 2, and Order 43, Rule 1, Subsection 1, Sub-Rule 1, CPC, the Allahabad High Court in Jila Parishad Badaun versus Brahma Rishi Sharma 1970 ALJ 5 held at an appeal against an ex parte order issuing injunction under Order 39, Rule 1 and 2 CPC. The trend at present is that normally such appeals should not be entertained, but they may be entertained only in rare cases where the order is manifestly perverse or suffers from lack of jurisdiction or bias is apparent. What is the effect of private alienation after the issue of temporary injunction? So, effect of temporary injunction is not to render a subsequent alienation of the property void. Any mortgage or sale of property by a party in violation of the order of injunction is not illegal or void. That means if there is a mortgage in violation of the injunction, that is not illegal or void. The effect of temporary injunction is not to render a subsequent alienation of the property void. Temporary injunction cannot make the subsequent alienation void. Okay. The only penalty for which the person who disobeys the order of injunction become liable is as provided under Rule 234 of Order 39 of the Code, namely the court granting injunction may order the other property of the person guilty of such disobedience to be attached and sold for awarding out of the sale proceeds. That means the penalty shall be for disobedience of the Rule 234 of Order 39. The court granting injunction, that means the court which granted the temporary injunction, may have the discretion to order the property of the person guilty of such disobedience to be attached. That property shall be attached and sold for awarding out of the sale proceeds. The compensation to the party on whose application the injunction order was granted and may also be detained in civil prison for up to 6 months. That means penalty shall be such, that means you have given a temporary injunction, without following the temporary injunction you sold out the property or mortgaged it. You mortgaged it or sold the property to a third party. That sale, that subsequent alienation shall not be void, but penalty shall be inflicted upon you for not following the order of the court. Court have the power to, or as per discretion of the court, to order the sale of the property of the person disobeying the order of the court. Attach the property and sell it out of the sale proceeds. Provide compensation to the person in favor of the temporary injunction was granted, and put the disobedient person in jail up to 6 months. Okay. Effect of private alienation after attachment. Section 64 of the Code of Civil Procedure Code provides that where attachment has been made, any private alienation or delivery of the property attached, any private alienation or delivery of the property attached or of any interest therein contrary to such attachment shall be void. as against all claims enforceable under the attachment. This section aims at preventing fraud on decree holder. Like there is an example, like a court has ordered a person's property to be attached. Even after attachment, he privately sold that property. That selling, that alienation, that transfer shall be void. That provision is incorporated in order to prevent the fraud on the decree holders. So section 64 of the CPC provides that where attachment has been made, that means property has been ordered to be attached. Any private alienation or delivery of the property attached, that means that property which was attached by the court was privately alienated, privately sold out, or privately delivered, or of any interest therein, contrary to such attachment, shall be void as against all claims enforceable under attachment. Appointment of receiver and commissioner. Discuss the principle on which a court appoints a receiver in a suit. Appointment of receiver is in the discretion of the court. That means it is the will of the court to appoint a receiver. This power shall not be exercised as the matter of course, for the reason that it can do not harm to appoint one. A receiver should not be appointed where there is a bona fide possessor of the property, unless there is some cogent ground for inheritance. There should be a well-founded fear that the property in question will be dissipated, or rather irreparable mischief may be done. There should be an actual waste or actual damage done by the defendant, showing that further waste or further damage is likely to occur if no receiver is appointed. The waste or damage should not be in the form of futurity, the violent wholesome charge. The violent wholesome charge in a plaint are held to be insufficient for the grant of the receiver. That means there must be a reason to appoint a receiver. That means irreparable damage must be made, or irreparable mischief may be done if receiver is not appointed. So appointment is necessary, then only receiver shall be appointed. Court, finding it just and convenient, may appoint a receiver. A plaintiff must establish a prima facie case before he can be entitled to deprive the defendant of his legal right over the property. That means there must be a prima facie strong merits over the case in favor of the plaintiff. He must establish his merits, that the property belongs to him. Then only court has the power to appoint a receiver which eventually deprive the defendant's legal right over the property. Plaintiff face an uphill task in the grant of relief claimed. So when there are debatable points to the title of the plaintiff, the defendant shall not be disturbed in his possession by the appointment of a receiver. Whenever the receiver shall be appointed, it leads to the disturbance of the possession of the defendant. The circumstances of the case and the strong likelihood of the success of the plaintiff's case, along with the risk of the loss to the plaintiff, that cannot be made goodwill to the guides for appointing a receiver. The sufficient care and caution are advisable to the appointment of receiver. It has been held by the Supreme Court that the receivership cannot be imposed by the court. Thus, where the receiver corporation made a request to be relieved as a receiver, the request was acceded to. Hindustan Petroleum Corporation Limited versus Ramchandra and Sons, AR 1994, Supreme Court Judgment 478. Number B, in the case of simple mortgage, if the property has been mortgaged, the plaintiff gets a decree for sale. There is a decree, proprietor gets a decree for sale, and he has no present right to be in possession of the property. The defendant's possession therefore cannot be taken away by the appointment of a receiver. Ordinarily, it is in discretion of the court to appoint a fit and a proper person to be a receiver. He should be an impartial person having no interest in the subject matter of the suit. It is pertinent here to note certain guiding principles governing the appointment and continuation in office of a receiver which have been laid down in the recent case of Das versus Das AI 2002. These principles are receiver. A receiver is the office of the officer of the court. He is not agent of any party to the suit, even though his ultimate possession may ensure to the benefit of possession of the successor party on termination of suit. Number two, the receiver is appointed for the benefit of all the concerned. He is the representative of the court as well as that of the parties interested in the litigation. The appointment of receiver by court in the interest of justice. Receiver is representative of the court subject to its order. Possession of receiver is the possession of the parties to proceeding according to their respective title. Any money in the hands of receiver is custodia legis for the person who can make a title to him. The receiver holds office not by virtue of his own right but by reason of the pleasure of the court supported by judicial principle. When a receiver is appointed, under a suit until judgment, he continues in his office until the termination of the suit by delivery of judgment. Receiver appointed without the tenure being defined continued till he discharged. After the final disposal of the suit, the receiver's functions are terminated, but still he would be answerable to the court as its officer until he is finally discharged. Court has power to continue the receiver in the exigencies of circumstances even after the final degree, in case a person appointed as receiver dies before he is discharged. In that event, his office becomes vacant. His legal representative cannot claim any right to succeed to the office. Even though they cannot succeed to the office of the receiver, yet the legal representative of the person being receiver are bound to account for the amounts in the hands of the receiver in case any loss is occasioned by the receiver, and such manner is due from such receiver. The purpose and object of appointment of receiver is for preservation of the subject matter involved in the suit pending determination of the rights of the parties thereto. Under Order 40 Rule 1 CPC, the primary thing the court has to look into as to how best the suit properties could be preserved without being wasted. The responsibility of the court becomes greater if competing parties vie between themselves to possess the suit properties. Receiver is appointed to create harmony and not to ferment disharmony. This is a well settled principle of law, Das versus Das above. In this instant case, the defendant in the suit was appointed as receiver and was asked to deposit 50% of the rent so collected in the court, but the defendant receiver did not comply with the direction of the court, so was asked to show cause as to why his property should not be attached and sold. Wow. Why his property should not be attached and sold. However, before any cause was shown, the receiver died. His heirs also did not show their willingness to furnish a statement of account and deposit 50% of the amount collected by receiver. In these circumstances, it was held that the substituted heirs of the receiver could not be considered for being appointed as receiver. It was also held that so long as the receiver is not discharged, their heirs are liable for liabilities in respect of property at their hands and accounts held by the receiver. But the property is land paying revenue to the government. The collector may be appointed receiver if he consents for it and the court thinks it fit. Thank you so much. This is Advocate Lakshya Lawyer signing off. If find any legal help, please comment to me. I will send you my contact details. You can get free legal aid also. Thank you.